Okay, so we've had a great morning of conversation here about token offerings, and we thought this would be a good time for some comic relief, or maybe just to help you fall asleep after the lunch. And so I'm going to do a short intervention to talk a little bit about research and what we know, particular in terms of legal research around blockchain and related issues. The short version, if you want to skip the rest of the presentation, is not that much, not enough, but work is ongoing and starting to ramp up. This is obviously something that's being hosted at Wharton at a research university. And part of what we want to do here is to try to both facilitate conversations between industry and regulators, service providers, and so forth, but also hopefully encourage conversations between academics and governments and practitioners. And that goes in both directions. So hopefully this will be somewhat enlightening about what's out there and some of the legal scholarship. Again, we'll circulate the slides. I've got links to a bunch of papers in here. But I'd also love to hear from you to the extent we have some time after. What do you think are open questions where academics who are hopefully not connected to any particular project or initiative have the freedom to explore in ways that would be helpful? So first point is that there's a lot of academic research on blockchain and cryptocurrencies outside of what we're talking about here. In particular, a fair bit of technical research by computer scientists and cryptographers and information security researchers working on improving consensus mechanisms and working on just studying what's happening on the blockchain. Interesting work on public chains like Bitcoin and Ethereum because you can get access to the full transaction history using that from a data science standpoint to understand what we can infer about how people are using coins, whether they're using them for investments or for transactions, for example, patterns of behavior and so forth. I put a link there to BlockSci. It's a new tool that a group, mostly at Princeton, of computer scientists has developed that's purely a tool to facilitate efficient analysis of blockchains for academic research much more quickly than you could with previous tools. So a lot of that work going on. The link at the bottom is a paper by several computer scientists, maybe a little outdated now from 2015, talking about basically what they see as the open questions purely from a technical computer science standpoint in this area. So if you're interested in that, there's some links there. There's also a decent, although still relatively small amount of business scholarship. So here, people asking the question, just what do blockchains do in terms of improving efficiency of processes, changing incentives, changing the structure of the way business operates? There's a ton of very shallow blog posts and even some books that talk about how blockchain is going to change everything, give all these use cases about how suddenly they're going to overwhelm everything that's there. This is some more serious work trying to delve in more detail into what really are the nature of the transaction costs, for example, that a distributed ledger system might be able to handle more efficiently than a traditional system, and what are the pros and cons, and so forth. One paper here, which actually I just got and haven't had a chance to look through, specifically in economics of ICOs and cryptocurrency tokens by a professor at Vanderbilt Business School. So this is not a whole lot, given how much research goes on in business schools. Again, I think we'll start to see more, but that's just one dimension of what's going on. What I really want to focus on, given our goal here, is legal scholarship. And the way that I think about this at a high level is that blockchains can function as a kind of law. They're a tool that can regulate behavior. And so they can have three different relationships to existing law in the legal system. One possibility, which frankly I would think of much of what we're talking about here, is as a supplement. So there's an existing legal regime, which may have its pros and cons, but is understood as a regime for a certain kind of activity, issuing equity in companies. And then we've got this new set of things that have a different mechanism. And the question is, where do they fit along those regimes? Do we need to change the regime a little to make them fit differently? But basically, the cryptocurrency-based activity is sitting alongside the existing functional legal regime. The second kind of scenario is a complementary situation where there's something lacking, there's some gap or big problem in the legal structure, where there's the possibility for a cryptocurrency cryptocurrency-based solution to fill the gap, to provide an alternative. And these are much more early and speculative, but one of the ones I tend to think about is in certain areas of intellectual property, where we have big problems. For example, what's called the orphan works problem, that there's lots of works that are out there that are actually in the public domain, but no one can verify that they are. It's certainly possible that someone has rights, and in most of these cases, the book or movie or whatever is 80 years old. Whoever was the original publisher has gone out of business, and it's impossible to find the rights. So even though something could be available legally under copyright law, for all practical purposes, it's locked up and can't be used at all. So this is something where we might think about building better distributed registry systems using blockchain technology that might complement the existing legal regime. So that's a second category of interaction between blockchain and the law. And then the third one is the substitute. The third one is a situation where the blockchain-based system actually serves as the sole legal regulator. And this is the one that people tend to jump to very quickly, but obviously is the one that's the most difficult. It's the one where the most burden is being put on the cryptocurrency-based system, and you have the biggest concerns about interaction with existing legal regimes. So there have been some legal scholars who have started to ask these questions, actually a fairly small number, and two of them happen to be in this room. And the setup, this was mentioned very briefly earlier, that typically where most people start is thinking about what kinds of things regulate behavior. The little graphic there is from a book by Lawrence Lessig called Code 20 years ago, which was really the most influential work in developing the law of the internet, or cyber law. And his basic idea was law is a thing that regulates behavior. It sets rules, it sets limits, but it's not the only thing that regulates behavior. So sometimes people do things because of social norms. There's no direct legal prohibition, but they still don't think it's going to be appropriate to do something. Sometimes they do things because of economic incentives, because of market forces, and sometimes they do things because of architecture. And you can think about physical architecture. It's not a law, but if you just can't walk through a wall. But software code serves as a kind of architecture. So the technology actually creates structures around what people can do. So you think about, for example, digital rights management technology makes it practically impossible to make a copy of something, even if it might be legal to, even if you might have the rights to, even if you want to, you can't do it because of the code. So that's long time basis of analysis in cyber law, and the same kind of analysis can apply here. And the big question is, to what extent does the code of these distributed ledger or blockchain-based systems operate as law? To what extent can we rely on the conditions, basically typically enforced through smart contracts on these platforms, as the sole determinant of what behavior is? And so you see this, to some extent in the way these various ICOs are structured. Rights and responsibilities can be defined very finely in the smart contracts of the offering, in a way that substitutes for a purely legal formal declaration that these are the rights you have, this is what you can do with the tokens. Now, the big debate is, to what extent can we trust the code as the law and defer to it, and to what extent do we need to find more hybrids and ways to evolve the law. Aaron Wright is the author of one of these works, along with Primavera de Filippi. They have a book coming out. I also have a paper and a book coming out. I think generally speaking, Aaron's a little bit more favorable than I am to being willing to trust code as law, but I think both of us would say when you actually get into it, it gets complicated. So that's the sort of high-level debate we're starting to have in the legal academy. And just given, we'll have a wrestling match later, maybe. But for now, I'll leave it at that. We can talk more if you're interested. Carla Reyes is someone who was an attorney at Perkins Coie, I think, who's now, I think, going into academia, has also been looking at some of these questions. So those are the high-level kinds of analysis where the legal academy is starting to think about these questions, but really we're just at the starting point. There's also been a lot of fairly narrow ticking off issues and addressing them, mostly about Bitcoin and cryptocurrency. So what kind is a cryptocurrency exchange or a wallet provider or regulated money transmitter, all of these kinds of issues. There's been a fair bit of legal scholarship trying to apply these different rules, which is fairly doctrinal and straightforward, mostly focused, again, still on Bitcoin or on cryptocurrencies used predominantly as currencies. This is the area where there's the biggest amount of work, but it tends to be the least groundbreaking. It's really just sort of blocking and tackling through the existing rules. A few areas where things seem to be going beyond that. One is smart contracts. So about 2 years ago, I went to a former colleague in this department who's a contract law scholar named Nico Cornell, and said, well, these things called smart contracts, what do you think about them? Right, you're a contract law scholar. You spend all your time going to contracts law conventions. You must know something about smart contracts. And he said, smart contracts? What are smart contracts? And so I explained to him what they were, and he said, ooh, that's really interesting. And we said, okay, maybe we'll work on something. And so he said, let me talk to some friends. So we went and emailed a bunch of friends who also are contracts law scholars, and none of them had heard of smart contracts. Now, there are some arguments that a smart contract is not a contract the way lawyers think of it, that it's not intended to be. We shouldn't think of it that way. But in the first instance, you think, what does a smart contract do? What is it called? Certainly, there's interesting questions about how it intersects with this large body of contract law that we have in all major jurisdictions. So he and I published a paper that's coming out in a couple months, analyzing what smart contracts are, again, fundamental principles of contract law doctrine, and ask the question basically, well, what's contract law about? What's contract law trying to do? And then what are smart contracts trying to do? And the short version, again, I will cut this short for now, but we can always talk later if anyone's interested. We realize that the contract law system is accomplishing a very different function than smart contracts. The contract law system is predominantly ex post. It's about the remedies. It's about something breaks down in an agreement, there's a dispute, and you have to figure out what to do and then how to allocate the rights and responsibilities afterwards. The smart contract is predominantly ex ante. You're setting up the terms in the code of the smart contract and then hitting go, and then it goes into effect. So even though a smart contract, we feel legally, if you look at the basic principles, at least under common law contract doctrine, is a contract under the law, it's doing something very different. So that's the line that we went down. There's some other authors I've got up here who looked at smart contracts under some different areas of law. You can think about a smart contract as self-help, basically saying, well, we might have a contract, but this is just a mechanism, a technical mechanism to implement something. So the example this paper gives is starter interrupters. This is the Raskin paper that sometimes people who lease cars will require that the person who leases the car put a device on the car that if they don't pay their monthly fees for the car, it remotely shuts off the car. And the argument is, well, that's called self-help under contract law, and that's sort of what the smart contract is doing. I don't entirely buy that, but it's a different thought. The third thought from the Lawrence Schultz paper is, well, maybe we should think about this under agency law. Maybe this is like we're creating a robot, some sort of intelligent agent, and saying you go and implement this set of contractual terms through the smart contracts, and then we can apply, again, a very well-established, very detailed body of law to understand at what point the responsibility of whatever the agent does, whatever the smart contract does, devolves back to the principal, the one who's instructing it. Lots more questions about what that means, but just, those are some of the areas where people are looking at this from a legal standpoint. There's also been some good other analyses, the Norton Rose paper in particular, on just analyzing basic contract law principles around smart contracts. And then getting more into what we're talking about here, there's starting to be some work by corporate finance and corporate governance scholars, more in Europe than the United States. And I'm more familiar with what's going on among US legal scholars. But again, most of this is trying to look through, let's say that we put some sort of securities transaction on a blockchain, or we want to create a derivatives exchange using cryptocurrencies. How does that touch on all the different laws in different jurisdictions? What are some of the concerns? What are some of the issues we need to work through? The Werbach paper, he's a professor at the business school at NYU, looks at, from a corporate standpoint, what if we use cryptocurrency tokens instead of stock? What if we use them instead of voting rights for investors? And sort of works through all those things from a basic finance perspective. Another area where the legal scholars are just starting to look at these questions, and I think would benefit from more of an understanding of where in practice things are really happening and where there are real challenges. Because so much of the starting point is you read these descriptions of we're going to build a DAO and it's going to be completely self-organizing and it's going to be run by AI and it's just going to take over everything by itself. And that's what the legal scholars react to. That's, of course, not what's happening on the ground in the real world today. Things are much more narrow and much more focused on solving real business problems. But it's helpful to understand what's actually going on, the kind of discussions that we've been having here, to inform some of the scholarship, which then hopefully can help inform some of the practice. And then finally, on the set of issues we've really been talking about, not a whole lot. So there have been a few papers, interestingly, going back a couple of years before the real explosion of ICO activity, asking the basic questions about is a cryptocurrency a security, is a token a security, essentially, going through the basic Howey test analysis in the US. But there really, to my knowledge, has not been a lot more scholarship since this real upswing in the last year. Now, there's a lag, and so probably people are working on this. But I think this is really an opportunity where hopefully you'll start to see more legal scholars get into some of the deeper nuances of what we've been talking about here, and that's certainly something that I hope to take away from this. As I think about it, there really are three, though, broad kinds of questions we might ask from just a purely academic perspective on this phenomenon. And only one is this issue of the classification of the tokens. That's critically important, but it's one piece. The second piece is on the issuer side, which I think we'll get into more also in the discussion this afternoon. What are appropriate governance structures, both from a legal standpoint and from a technical standpoint? How does it make sense to set up these kinds of entities most effectively? There's been some scholarship on governance around blockchains, mostly though focused on governance for the networks themselves, issues like the Bitcoin scaling debate and the Ethereum hard fork after the DAO. So there's been some work looking at these questions, trying to apply basic governance principles to them. But I think we have a real gap in starting to apply them to what's going on with all these ICO projects. And then the third piece, and again, we got into this a little with Luca's discussion, is what these new vehicles means in terms of tokenization of assets more broadly, the notion of changing the nature of property. And there's been a little bit of scholarship about this. The paper I linked to there, Josh Fairfield, is a cyber law and property law scholar. And so he did a piece thinking just in very general terms, doesn't talk about ICOs at all, talks about registries mostly, but thinking about what happens if we start to tokenize more sorts of things. What does that mean if you go back to basic notions of property law and property theory? And I think that's also going to be a really fruitful area for legal scholarship. So that's, to my knowledge, a basic overview of what's out there. As you see, a whole lot of questions that remain to be answered. The big issue that we face is this one, which is what's sometimes called the law of the horse problem. Back during the early days of the internet commercially about 20 years ago, Frank Easterbrook, who's a very famous judge here in the Seventh Circuit in Chicago, was in a debate with Larry Lessig, I think, about is it valuable to talk about cyber law? Lessig and others, I was part of that group as well, was saying that the internet is so new and so big and so transformative. We need a new form of legal scholarship, a new area to focus on internet cyber law. And Easterbrook said, no, you don't. Said, think about horses. We could say there's a law of the horse, or maybe when people cared out 100 years ago, law of the horse. So we'll have criminal law and horses when people steal horses. We'll have tort law and horses when people get thrown off of horses. We'll have property law and horses. We'll have all these things, different aspects of horse law. And he said, well, no, that's crazy. We don't have that. We don't have a law of the horse. We have criminal law, and if you steal a horse, then that's one thing. If you steal a car, it's something else. We have tort law. And if you get injured by one thing, you get injured by another thing, it doesn't matter. That's really not the right category. It's not really the locus of inquiry. That's really the big challenge to cyber law, and those of us in the field push back and say something's fundamentally different here. It makes sense to actually think about law for the internet because the internet is not just the real world, except it's online. It's fundamentally different. I tend to think the same is true here. I tend to think that there certainly are analogs, certainly valuable to think about basic principles and established concepts of property and contracts and so forth. But we need to understand that, the world with these blockchain and distributed ledger systems, it's not going to work exactly the same as traditional kinds of securities arrangements or company arrangements or anything else. So we need to really identify what those differences are and then how to address the legal issues in that context. So I wanted this to be very brief, hopefully give you just an introduction of some of the ways that we're thinking about this. But as I said a few times, really the main reason is as an invitation to all of you to help me and us and the Legal Academy more broadly understand what's needed and what can be helpful to understanding the issues better. So with that, let me stop. I have some time if people have questions or have suggestions, do that. But if not, we can just go on to the next session. So I'll open it to, yes, Josh.
I'm just curious, are there any things that practitioners can help you with? Like, are there things you're looking into where you're looking for assistance from people?
Yeah, so I mean, I don't want to say like, particularly for my paper, but specific examples. So what's actually happening and where is there a conflict in the real world? I mean, some of that we were able to see, but some of it, it's not clear that this is a hard issue where you get to something and say, I don't know what the answer is, and maybe there's not a clear answer. But it would be helpful for someone to just speculate on different possibilities and analyze it within those general frameworks. So the concrete examples are really the things that are helpful. So, and I should open it up. We have Jill, we have Aaron, we have other people here who are academic scholars who may have input on that as well.
Kevin, do you think lawyers need to learn code with respect to smart contracts?
So do they need to? No. Should they? Yes. Would it be good for more lawyers to learn how to code? Would it be very valuable for more law schools to teach coding? Absolutely. I think lawyers that are dealing with this area need to be exposed to it and need to understand what coding is. But this is the challenge. Is sort of how technically sophisticated do you need to be to understand it? There's a barrier, but you don't want to say sort of we're going to exclude anyone who's not can't like pass some programming test. But no, I mean I think we do.
Judge Easterbrook would have a different view on that, Kevin?
On what? Whether lawyers should code?
Well, I mean, if you don't have a law before us, then what difference does it make if we know how to code?
Yeah. So no, exactly. You're right. That's exactly the dividing line. Right. And the question is, what is it about coding that makes it different?
Being slightly sarcastic.
No, but you were actually being sarcastic in an after way.
And actually, that's not limited to lawyers, right? So
learning to code, sure.
Yeah, that they should have some basic knowledge about coding.
Yeah.
Right. I think that's
I'm
should
just
apply to
thinking,
anyone.
so
And just let me
okay,
one thought. There is one German law that actually hinders code from being law, and I mentioned that in previous discussions. And that is simply standard business terms only become part of a contract if the user gives the other party, the one who needs to accept that, in an acceptable manner, the opportunity to take notice of their contents, right? So currently, as long as you cannot assume that everybody can read the code, it's not legally possible to conclude bindingly by code on the contract in Germany.
But this is exactly the issue. So the issue of code as law is you can have a situation where it is not law, right? This is not legally enforceable, but it is enforced in practice. So you have let's say you have a smart contract and you put some cryptocurrency in the smart contract and it transfers, okay? And now you no longer have the coins. You don't know who the counterparty is because it's pseudonymous. The counterparty has no legal claim. You're right. Under German law, that's not a legally enforceable transfer. It has happened. So the code is law argument is that's a scenario where the code acted as though it were law, even though it isn't. Now that's a very simple scenario, and then where we go from there is okay. How does one deal with that situation?
Creates order without law.
Order without law is another.
Well, and that's questionable, if that is actually the case, because if you would then go to court and saying, if you happen to know who your counterparty is, right? There's all sorts of practical questions involved, but assuming you can solve those purely practical questions, then I think it is actually enforceable, right? If the understanding of the one sending the coin was due to information on some web page, whatever, different to what actually happens with this coin, then he can claim it back. Right?
Yeah, so I mean, of course, I became a law professor because I didn't want to have to deal with practical questions. But yeah, so I mean, these are exactly the kinds of issues that the contracts ex machina paper I did talks about, Aaron and Primavera's paper talks about, and my other paper talks about. So yeah, these are things that legal scholars are starting to think about, but more of them need to, and again, needs to be more informed by what the actual legal regimes are and so forth. Yeah, Jill.
So, real world examples are great. Kevin identified areas where there might not be a law answer, and sort of flagging the question might prompt academics to write about it. But the other area that I think this discussion can be really helpful for is, it seems to me, a lot of what we're talking about is using new and existing legal rules in different ways, from traditional securities offerings, traditional currency, and so forth. And it's really useful for even practitioners who aren't writing in cyber law to know, gee, they're using general solicitation under Rule 506 in a way that regular IPOs are not, or regular private placements are not, or gee, this is an application of Reg A Plus that really works, or something like that. So I would encourage you all, because even the sort of list of scholars who are not writing specifically on Bitcoin or something like that are very interested in those questions, and that translates, I think, into what policymakers are thinking about when they re-examine regulation and regulatory changes.
So I think part of again the call here is we are happy to be a mechanism if if there are those kinds of questions that either you think there's something that someone should be writing about, or it would be helpful for people to examine it, even if not something that I or the folks in this room are experts on, we can probably direct you in the right place. And it's definitely something in terms of the ongoing work of the Zicklin Center and us at Wharton, something we'd love to do in this area. So thank you for your indulgence for this. Again, our goal here is to bring together different voices, and part of that is regulators and industry, and part of that is also the academic research component of it. So we'll stop there and turn off the cameras and go back to our regularly scheduled broadcast. All right.